Hey, how you doing? This is Adam Post. Major Supreme Court win, 9-0. A major DEI hiring fail. A straight white woman won a reverse discrimination case in front of the Supreme Court. Why? Because she was discriminated against because she wasn't gay enough. She wasn't gay enough. How gay do you have to be? More gay than she was. She wasn't bi, she's straight. Okay. I don't know what her college years were like or if she's ever had those thoughts before, but none of that should impact whether or not you're going to be hired. Throughout the country, in a few different districts, there were rules that set a higher bar that, yes, if you were part of a majority group, meaning that you were straight or you were white, or God forbid you were both of those things, you would have to show more bias, more than somebody else would have to show if they were a minority and they were claiming racial discrimination preventing them from getting a job or a job opportunity. Now, none of that sounds legal, and it's not really legal, and that's what the Supreme Court made clear. Even the liberal justices went along with this. I will say, I don't know what to exactly make of this. I mean, it is a new rule. It does seem like there's some deal-making behind the scenes at the Supreme Court. There are many important cases they're handling. They're trying to show as much agreement on decisions as they possibly can in the age of Trump 2.0. And they've really been delaying some cases that Trump has had where he should have won a long time ago. For example, they took 2 months to decide that, yes, the President of the United States, the head of the executive branch, is allowed to fire people that are under the executive branch. That took them 2 months to figure out. That was delayed as long as possible to slow momentum coming out of the Trump administration. And the reason to slow momentum is to prevent him from making certain changes. The Supreme Court, even though there are a couple of great justices on the Supreme Court like Clarence Thomas and Alito, they are still part of the D.C. world. And the D.C. world does not want change, even if our Constitution guarantees us that change from the executive branch. So on this one, they agreed, okay, sure. Just because you're white doesn't mean you get to be discriminated against in your job hiring opportunities. From fake news CNN. Supreme Court sides with straight white woman in decision that makes it easier to file reverse discrimination lawsuits. Reverse discrimination is just discrimination. It's called reverse discrimination because it's a reference to say like, oh my God, white people could be discriminated against? Yes, they can be, and it's been going on now really since the 1980s when you get into the corporate environment. But now without question, it's well decided that discrimination cannot reach into the workplace this way. You can't just say, oh, it's for a good reason. We want equality. We want different kinds of voices. So we're going to exclude these people or those people based on their sexual preference or whatever they did in college. We covered this specific case a few months ago, and it did look pretty promising that, yeah, this was going to get overturned and this was going to get dealt with. Her final case still has to go down to a lower court, and they still have to fight it out. But she doesn't have to show that just because she's straight or just because she's white, that she was more discriminated against than anybody else would have been if she looked a different way or had a different skin color. CNN was trying to promote the idea that DEI is still relevant, that you should still be able to discriminate against people in the workplace. It hasn't gone over so well. From CNN, Trump and GOP are overreading a landmark Supreme Court decision as they target DEI, according to legal experts. Legal experts are attorneys, and there are attorneys on every side of every possible situation and every controversy. So CNN, very helpfully for what their agenda is, went out and put together a bunch of lawyers that said, oh, sure, don't take the Supreme Court Harvard admissions decision that showed that, no, you cannot discriminate against people based on race on college applications. Don't take that and try to apply that to other situations or other work environments, for example, because going to college is not like going to work. You can go to college and not get it discriminated against. That's fine. But once you get into the workplace, we're going to discriminate against you, even though we couldn't do that in college. They try to make the argument it doesn't really hold together, and now it gets kind of decimated by this recent Supreme Court ruling. This woman's situation was pretty ridiculous. From the Washington Post, Supreme Court sides with woman claiming anti-straight job discrimination. Marlene Ames filed a job discrimination lawsuit in 2020 after she lost out on 2 jobs to colleagues who were gay at the Ohio Youth Department. She explained it in detail, and I covered it in a prior video, but they really were picking people for jobs that had no qualifications compared to what she had, but they seemed to like the right kind of people in their own personal sexual preferences, so they got opportunities that she was basically never going to get. And there was a lot of money at stake, and she didn't get access to that opportunity. So she sued. Vox, which is about as far left as you can possibly go, is trying to make sense for its audience about what's going on. Because they still believe in DEI. They want it to continue. They want more discrimination in the workplace, in every possible place you can get it, for as long as you possibly can. From CNN, court sides with straight woman in decision that makes it easier to file reverse discrimination lawsuits. The Supreme Court sided with a straight woman in Ohio, who also happens to be white, who filed a reverse discrimination lawsuit against her employer when her gay boss declined to promote her, somehow finding 2 other gay applicants to take that job. And they're out there. There's no problem with that as long as they're qualified, but your sexual preference is not a qualification. The ruling makes it easier to file discrimination lawsuits in some parts of the country. And it also lets people know if you've been discriminated against because you're white or you're straight or you're part of some majority group, it's just wrong. You do have a case. Despite the politically divisive debate playing out over workplace diversity efforts, which for the most part are discriminatory, a fight that has been fueled by President Donald Trump, a unanimous coalition of conservative and liberal justices, all the Supreme Court justices, were in the majority. Justice Ketanji Brown Jackson wrote the opinion for the court. Which, if that sounds a little bit backwards, that's because it is. She's the same person that when she was in front of the Senate, could not describe what a woman was, wanted to be on that side of the equation. But in this case, she must have seen an opportunity. Even a broken clock can be right twice a day. Ketanji said this, quote, "Our case law thus makes clear that the standard for providing disparate treatment under Title VII does not vary based on whether or not the plaintiff is a member of a majority group, according to Jackson." Marlene Ames started working for Ohio state government in 2004, so she's been there a while, and steadily rose through the ranks at the Department of Youth Services. She claims that in 2017, she started reporting to a gay boss, and was then passed over for a promotion that was offered to another gay woman. The issue here really is, if you're going to protect the workplace from discrimination based on people's sexual preferences or race or any reason, if you're only going to hire based on merit, it has to apply to all races, sexual preferences, all kinds of identities. You can't just say, oh, for certain races we can discriminate, and the federal government is supposed to back that up. They can't back that up. It's not in the Constitution. This is not South Africa here. And South Africa has 140 race-based laws against white-skinned people. They really do. I wish it wasn't true, but it is true. And if you don't stop that kind of discrimination, that's the kind of thing this can turn into eventually. Ames is challenging a requirement applied in 5 appeals courts across the nation, and those are based on geography, that majority Americans raising discrimination claims must demonstrate background circumstances in order to pursue their suit. That's a different requirement. A plaintiff might meet that requirement, for instance, by providing statistical evidence documenting a pattern of discrimination against members of a majority. Ames couldn't do that, and so she lost in the lower courts. How are you supposed to have statistical information based on your job in your office of 1 gay woman and maybe 2 other gay hires? Like, that's not enough statistics to prove anything. Either you're doing it or not. It shouldn't matter what her sexual preference is or her skin color. An employee who's a member of a minority group does not face that same initial hurdle. And that would mean if she was black, but she was also straight, she might have had a case immediately that she's now had to take to the Supreme Court just to protect normal civil rights. The lawsuit requirement was rooted in the notion that it's unusual for an employer to discriminate against a member of a majority group. But neither federal anti-discrimination law nor the Supreme Court precedent speak to creating one set of requirements for a majority employee to file a discrimination lawsuit and a different set for a minority employee, so there's no basis in the law for this. During oral arguments in the case late February, it was clear Ames had widespread support from the Supreme Court justices. Citing the background circumstances requirement, the Cincinnati-based 6th U.S. Circuit Court of Appeals ruled for Ohio. Federal appeals courts based in Denver, St. Louis, Chicago, and Washington, D.C. applied that same standard, according to court records. Every Supreme Court justice agreed, we only have 9 of them, that the analysis from the 6th Circuit was wrong. The case landed on the Supreme Court's docket last fall, about a month before Trump was elected on a pledge to clamp down on diversity and inclusion efforts in both the government and the private sector. The administration has taken a number of steps in that direction, including attempting to cut funding to entities federal officials allege have supported DEI efforts. Many of those actions are being reviewed by the courts. D.C. judges and also some hand-picked judge shop judges are doing everything they can to put out national injunction after national injunction to try to reverse or slow down Trump's policies. And from Vox, they do not like this outcome. The Supreme Court's rare moment of unanimity against the DEI rule explained. They say Ames versus Ohio was an easy case, even if it touched upon contentious issues. People on the left have no problem bending the law and bending interpretations to fit whatever their desired outcome is. It's the conservative justices that say, okay, well, what was originally written in the Constitution? Because that is what we're promising to citizens when they live and work and contribute to this country. In this case, according to Vox, they were stuck with doing the right thing. On Thursday, the Supreme Court handed down a raft of mostly unanimous opinions, 3 of which reached a conservative outcome, despite the fact that they were each written by Democrat justices. Sometimes the law in a case is clear. Ames versus Ohio Department of Youth Services, authored by Biden-appointed Justice Ketanji Brown Jackson, was the first of these 3 cases. It involved a clearly illegal background circumstances rule. This rule imposes a slightly higher burden on members of majority groups, such as producing statistics that are impossible to produce, which is maybe not a small burden, it's kind of a big burden. And that includes white people, straight people, and Christians, who allege workplace discrimination compared to members of minority groups who bring similar claims. That doesn't sound right. It's not right. And now the Supreme Court just let people know, no, it's not right. You can't do that. As Jackson writes in her opinion, this disparate treatment of majority group plaintiffs is not allowed. She quotes the Supreme Court's opinion in McDonald versus Santa Fe Trail Transportation Company from 1976, which held that the federal law governing employment discrimination prohibits racial discrimination in private employment against whites on the same terms as racial discrimination against non-whites. Why did it take this many decades to come up? I don't know. The plaintiff in Ames alleged discrimination based on sexual orientation rather than sex, rather than race. Marlene Ames is a straight white woman who was passed over for a promotion that was ultimately filled by a lesbian candidate. Was that woman always a lesbian? We don't know. Were they born a biological woman? We also don't know. Marlene was later demoted and replaced in her previous role by a gay man. She claims that she was discriminated against because she's straight. Neither the lower courts that heard the case nor the Supreme Court, however, actually determined whether Ames is a victim of anti-straight discrimination yet. Instead, both the trial court and an appeals court, the United States Court of Appeals for the Sixth Circuit, ruled against Ames because of an unusual rule applied by the Sixth Circuit and a few other courts. Under this rule, the plaintiff loses their case unless they can show at a fairly early stage, quote, background circumstances to support the suspicion that the defendant is that unusual employer who discriminates against the majority. This obligation applies only to majority group plaintiffs. Literally nothing in the Constitution about that, nothing in law to support that. They just kind of did it. This rule is not consistent with federal law. In addition to quoting the McDonald opinion, McJackson also quotes the law banning workplace discrimination, which makes it illegal, quote, to fail or refuse to hire or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment due to factors including race, religion, sex, and more. This language treats all plaintiffs exactly the same, regardless of their majority or minority status. In Jackson's words, quote, by establishing the same protections for every individual without regard to that individual's membership in a minority or majority group, Congress left no room for courts to impose special requirements on majority group plaintiffs alone. Indeed, Ames is such a straightforward case that it's baffling that the Sixth Circuit's background circumstances rule, which did not just happen only in the Sixth Circuit, we covered that before, and it's existed in some courts since 1981. So how did it survive as long as it did? McDonald, after all, has been the law for nearly half a century, since 1976, and it was decided before any lower court embraced the background circumstances rule. This one Supreme Court decision is going to roll back a tremendous amount of nonsense in the workplace. This decision about workplace discrimination is expected to change the way that employment law is practiced in the U.S. and make it easier for people to lodge claims against their organizations for discrimination. Here's what one expert had to say. Quote, we should expect to see this trend continue and see an uptick in these so-called reverse discrimination claims brought by men who are not members of a historically disadvantaged group, according to Michael Steinberg, a labor and law employment attorney who told this to Fortune. Quote, now they'll be armed with the Ames case, which confirms that the same framework for discrimination applies to everyone. The Supreme Court's decision comes as diversity, equity, and inclusion practices in corporate America are under attack. Over the past 2 years, many companies have rolled back their DEI practices following the Supreme Court's decision to ban affirmative action in colleges and universities' admissions. Although that decision did not mention employers or specifically mention companies, it proved to be an inflection point around cultural attitudes towards DEI and led to ripple effects in the working world. That was the beginning of the end of this nonsense. This is the next step in the end of this nonsense. The Supreme Court has said, 9-0, that you cannot discriminate against people even if they're in a majority group. Major change, and it will affect workplaces everywhere.